it's Jen Suzuki, and I'm in the industry. I meet some of the greatest leaders out there, dealer execs, dealers, GMs, and I'm bringing them in the studio to talk to me about what's making their business pop, what's accelerating their growth. I'm sharing my own personal strategies for your sales teams, so I'm ready to get after it. Are you? All right. Welcome back, listeners. I have two guests with me today, and we are going to dial into a Federal Trade Commission vehicle shopping rule, oftentimes called the CARS Act, today when we talk about what's happening in government regarding this. And then we're going to kind of talk about how it's impacting dealers and dial into some of the document processes that are going to be impacted by this ruling. First, let me introduce Matt and Jason. So Matt, product development attorney, where he focuses on drafting and revising Reynolds and Reynolds law branded documents. And he always wants to make sure that we're meeting market demands and help navigate state and federal laws and regulations. Welcome, Matt.
Thank you so much. Excited to have you. Excited to be here.
Woo! And next up, we have Jason Gaskill. He's the sales director for the document services compliance team at Reynolds and Reynolds, and he directly assists dealers in reducing risk and improving standardization in the F&I office. Welcome.
Thank you, Jen. Happy to be here.
Well, guys, a lot going on. Let me just bring our listeners up to date. The Federal Trade Commission's new vehicle shopping rule, it sparks a lot of controversy out there, and it's been debated due to concerns about the potential negative impacts on car buyers. So a lot of people are arguing that this rule is going to introduce added costs, more paperwork, and it's really going to lengthen the sales process. And, you know, none of that sounds interesting for us as those retailers who are trying to transact in a shortened cycle in buying a car for those customers out there. We don't want to lengthen it. And ultimately making vehicle shopping a bit more burdensome experience for people that are buying cars. And so this ruling, it's attracted a lot of attention from members of Congress who are scrutinizing the FTC's regulatory practices and considering legislatives' action to address the perceived flaws in this rule. So Mike Stanton is the president of the National Automobile Dealers Association. He is representing the interests of auto dealers across the country. And he believes that the FTC's vehicle shopping rule will impose unnecessary burdens on car buyers and leading to increased costs of the paperwork and the extended sales process. And he also agrees that existing laws already adequately address the issues that the new rule aims to tackle, and that the FTC's approach represents regulatory overreach. He supports the FTC Redo Act, and he's calling for more cautious and consumer-friendly approaches to regulating the auto industry. With that being said, let's welcome our first guest and really try to get a grip on how you see. So let me ask you this. If you can start by a little background on Reynolds and even the document services and what you do for dealers, Jason, could you give us some insights?
Absolutely. So Reynolds and Reynolds has been around since 1866, been around a long time. We have worked directly with the automotive industry for 97 years. And we acquired the Law brand back in 1994. Really, since then, Reynolds Document Services has become the lead provider for marketing, for documents, for supplies. And in 2021, we launched the document compliance team. And our primary goal with the document compliance team is helping dealers identify areas of risk in their F&I documents. We also work a lot with groups on standardization and consistencies and standardization projects.
Well, I was with Reynolds many years ago, and I can tell you there's a lot of forms, a lot of printing, a lot of documents, a lot of signing, a lot of things. So I can understand why we have departmentalization for stuff like this, and why we want to help support dealers and stay compliant. And there's a lot of paperwork when people buy cars. Why are documents so important to car transactions, Matt?
Jen, that's such a good point. And I had a fifth grade teacher who I loved, who always reminded us the six most important questions, right? Who, what, where, when, why, and how.
Yes, I remember
And
that.
that's what documents are for a car transaction, right? It is answering all the critical questions we need to get solved before you walk out the door in that brand new fill in the blank, right? And documents, whether paper or electronic, will always be an important component to creating a great customer experience because it outlines who is responsible for doing what and sets the terms. I mean, think of it in a practical situation. Every time you had a customer call you to complain, or you're the GSM or the GM or the dealer principal, what's the first thing you do when you said it was a sales complaint? I'm really upset about how this transaction went. You went into your system. You talk to the manager, right? You pass them up. But once you can't do that and the buck doesn't stop there, the thing you do is you pull up the buyer's order, you pull up the lease order to figure out what happened.
Yes.
And that's why documents are so important, because it is what describes the relationship and it helps describe what happened in the transaction.
And there's a lot of processes with documents out there, a lot of things that have to be filed to stay compliant with the state. And, that law brand you mentioned. And was this a company that Reynolds acquired?
Acquired, yes, back in 1994.
Okay, that's what I thought you said. So dealers on Reynolds systems might see this name, and it's a recognizable name in the industry when it comes to transactions and documents. But from your perspective, what does the law brand bring to the table for dealers, Jason?
Right. So most dealers are familiar with the law brand primarily through the retail installment sales contract, the 553, which we have available in every state. What a lot of dealers don't know is that we offer a turnkey state-specific set of F&I documents in every state, and they're available in both print and e-form format.
Okay.
Which makes those transitions from paper to e-forms a lot easier. The forms themselves are written in language that's very easily understood. There's no legalese. They are all designed to support each other, which is important. We've got a trained team of compliance consultants that can help dealers manage risk, help identify areas of risk within their document sets. And then probably the most important aspect, the most important benefit of the law brand is we maintain and monitor the forms for state and federal compliance. And we do that through our in-house team of experts, partnered with our outside resources as well. So we work with local counsel in many of the states we operate in. We work with state ADAs in some of the states, and monitor all of the state legislative sessions. And that really comes in big. That's very important when you're dealing with something like the vehicle shopping rule, which is on the horizon.
I imagine you guys are ramping up over there.
Oh, yeah.
Yeah. Well, speaking of that cars rule, Matt, we've been hearing a lot about this FTC recently, and maybe you could give us a little bit of a higher level summary and tell us what's going on with this rule.
Absolutely. So I have to admit to you, I've been bugging Jason about this thing and most of the product development team since the day the final rule was released. So he's probably heard enough of it from me. But at a high level, right, what's going on is there's really 6 key requirements from the rule. The first one is the 16 prohibited misrepresentations. Let's cut that. The first is the 16 prohibited misrepresentations. The second really focuses in on what is included in the vehicle's offering price and when you have to present that offering price to the customer. The third are additional disclosure requirements when you're presenting a monthly payment or comparing monthly payments together. Dealers are also prohibited from selling valueless products and services. There's increased record requirements as well, but the one that's causing a lot of questions and concerns, at least for us on the programming and the form side, is really getting to this idea of getting the customers express informed consent for all charges. Because we don't know what it is, right? They define it by what it's not. And so we have to sit there and kind of think through, what is it? How does a dealer get it? And how do we document that it happened? But the good and bad news, right? So the good news is that the rule is currently on hold. The FTC has put the rule on hold pending the final decision in the Fifth Circuit. But just because the rule is pending doesn't mean dealers should be. At this point, there are a number of FTC enforcement actions that highlight a lot of these issues and bring them to the forefront. And as a result, dealers really need to consider being proactive on these and a couple more issues in the marketplace. Jason, I know you've been talking to a lot of dealers on proactivity and what they can do to get ahead of the curve or at least stay with the curve. You want to share a little bit about what you're experiencing?
Yeah, absolutely. My team's in dealerships week in, week out, and we kind of get a mixed review of how the dealers are seeing this and what the reaction is. We have some dealers that we work with that are, in a holding pattern. They want to wait and see and find out what the final rule looks like, and not really make any changes. Personally, and I think from a company standpoint, we think that's a bit of a mistake. Ideally, what we're preaching is be proactive. As Matt has mentioned, a lot of the things out there that will be incorporated into the vehicle shopping rule, there are already things now, and if you have problems now's the time to address them. So being proactive now, I think, can put you in a much better space as we get closer to finding out exactly, what this is going to look like.
Well, the dealers are certainly at risk if some of these issues now, even before the car's vehicle shopping rule goes into effect. And I think I heard you correctly, Matt. Is this true?
Unfortunately, yes. The FTC is using its enforcement authority to try and address a lot of these issues with enforcement actions. And these are resulting in 6, 7, and even 8-figure settlements with dealers and dealer groups around the country.
This.
And the hard part is I've heard a lot of dealers go, well, Matt, I'm not on the FTC's radar. I don't care if you're a single point in the middle of nowhere or if you're a publicly traded dealer group, you are on the FTC's radar. Consumer complaints are a large resource and referral source for enforcement action. And your customers are following you. They're seeing what you're doing. And I think that's what a lot of folks get with the misconception is they see the rule as the beginning of the story, when in reality, it's probably closer to the middle of the story with these enforcement actions and kind of figuring out what dealers need to do to be prepared for, so they're not, let me start again. A lot of these folks see the rule as the beginning of the story. But for me, I see it more as the middle of the story because these FTC enforcement actions really demonstrate some of the key concerns dealers need to be thinking about in their processes. They need to be thinking about in their forms and how they're treating the customer in their transaction.
So earlier, we talked a little about prohibited misrepresentations and we obviously know that we can't lie to customers, but maybe you could give some examples of misrepresentations.
Yeah, you're absolutely right, Jen, right? We can't be lying to customers and saying things like they won a prize when they didn't. But we also, transparency is far much more than just not telling the truth, right? And being transparent with our customers is paramount because otherwise we can't create a great customer experience. And that is the goal 100% of the time for our dealers. Right. So the other things you got to think about when you're talking about prohibited misrepresentations are things like omitting key information. So for example, if we're talking about a product or service and there are limitations to coverage, we need to talk about those. We need to bring them up to make sure that that's not an issue here. And then the other thing that Jason and I have been talking with a lot of dealers about in their forms practice is really inconsistencies. So things where we say one thing in one document, another thing in another document, and maybe even do a third thing outside of that. So I know Jason's been dealing with that a lot. So Jason, you have anything you want to throw in there?
Yeah, conflicting language is one of the big, it's one of the 5 major topics that we can help identify in the reviews that we'll talk about a little bit later. But it is widespread. We see quite a bit of it. A great example of conflicting language that can cause problems for dealers would be using arbitration clauses. So I already mentioned the 553 retail installment sales contract. We offer a version with and without arbitration. Arbitration is the most widely used version across most states. And if you have a dealer using the law contract with arbitration, and then let's say they have arbitration built into their buyer's order, or they're using a standalone arbitration agreement that is of different language, that either custom designed or from somebody else, drafted by somebody else, there can be problems, because if the two arbitration clauses do not get along, the dealer's at risk of losing that protection, which can be very important. Some of the key things that we see, key conflicts, would be what arbitration companies are they using, who's paying for the arbitration. That's very important. And then is class action arbitration included? So arbitration is the big one, but there are others. So that's certainly a great example of
Misrepresentations.
Correct.
So another thing that's getting a lot of attention is voluntary protection products. And maybe we could dig into that for a little bit and tell us what dealers should be really thinking about right now. Jason?
Yeah. So the biggest one is we've already talked about transparency. Are the dealers conveying that these optional products, these voluntary protection products, are actually optional? And are they doing that in a clear and concise way? What we see in a lot of the dealerships that we work with is they're using menus that look more like marketing tools. Oftentimes you'll see good, better, best, or gold, silver, bronze, with different packages involved, with a very small disclosure in the bottom right that is not always ideal. So one of the concepts that we preach with compliance team is something called strategic redundancy. And that just means having additional coverage on some of the really important hotspots in F&I documents, the highly litigated topics, such as optional products, where there are payment packing allegations, and we see lots of cases across the country where a little bit of transparency, a little bit of strategic redundancy would have gone a long way. In fact, we have been working on our optional products disclosure, a revision that we are planning on having ready for the vehicle shopping rule that I've been working very closely with Matt on. He can probably give you a little update on that one.
Yeah, what I love about the law brand, right, is we have a complete set of really strong documents in the field, but I will never stop making them stronger if I can. And these FTC enforcement actions are great examples, because we continue to monitor and see what's going on, see what the concerns and the pain points they identify, and how our forms can help dealers address those concerns. So the optional product disclosure is a great example. So we've started by moving away from check boxes to actually filling in what the forms are, or what the products and services are. Let me start again, cut that. Where was my sentence at? Forgive me, I've completely forgotten.
You're good.
So we're handing it off. So yeah, one of the things I love about the law brand is we really focus in on what's going on in the marketplace, what's going on in the regulatory environment, and what should dealers be aware of in their forms and documents. You know, I was joking with my boss, I believe every one of law brand documents are strong, but I will work tirelessly to make them stronger every chance I can. And this is a great example of that one. It's already a great document in the field, but with the FTC enforcement actions and with all of the attention on optional products, we really need to take a look and see if there's a way we can improve it. And we've identified a few ways. For example, we have an actual list. So you'll list the direct product on it. You'll list the actual price. You will make it clear to the customer that it's optional and it's not required to buy the vehicle or lease the vehicle or secure financing for the vehicle. It also brings out the point that each product has their own terms and conditions that the dealership and the consumer should both understand before going into completing it. And it also reminds the customer that they have the right to walk out of that up until completing the transaction to change their minds. So we're excited. It's in the final spots of development, and it will be released here soon. And then we'll start the track of introducing it into the marketplace.
So it sounds like you guys are really getting ahead of this. At the same time, improving to stay relevant and ensuring that you're protecting dealers. So bottom line, Matt, Jason, if you're a dealer out there right now and they're listening to this talk about the FTC's enforcement actions, 6- and 7-figure settlements, and the vehicle shopping rule on top of all of that, what would you do, Matt?
Obviously we don't give legal advice or counsel. We don't kind of walk through that. This is really the start of the conversation. So for me, what I would do is two things. First, I would identify the pain points that the FTC are identifying in their enforcement actions. What is causing issues? And I would look at those and go, are we doing anything like that? Are we doing something close to that? And then I would sit there and go, well, how are they describing the problem? Because is that something that's going on here? The second thing I would do is I would take a look at the customer transaction. Jen, I know one of the things you preach on this podcast is creating an amazing customer experience. And I think dealers work their tails off to do it every chance they can. But I think it's also important to look at the transaction as a whole, as if the customer has never bought a car before. Ask the questions that they would ask. Think about your answers to those questions. How do we do it? What's the holdup? What's the confusion? And really think about how we can create a good experience for the customer that reduces those things and explains the questions that they may have. I know Reynolds, I joke and tease, the reason I came to Reynolds is because they lead, they don't follow in this industry. And it's always exciting to be here for that. We've got a couple really great programs. I know Jason and his team do the F&I document review, and I'll let him tell them that. But we've also got the Reynolds Retail Summit coming up here in August, and we're excited to share about that. So, Jason, you want to kind of introduce it for folks?
Yeah. Well, we've talked about proactive and how important that is. And one of the first things that I think would be important to do would be to reach out to the document compliance team and get involved with the document compliance reviews. They're completely free, and they're available to dealers on all I was doing so good.
Yes, you were on a roll.
You're on. I mean, we were going great. It was one take wonder, Jason, right until the 8th question, right? Jeez.
I'll be right back. I'm going to go do a shot. You definitely have to cut that out.
Yes.
That would be really funny, though. No, don't worry about that. We'll take
All
quiet.
right. Okay. So we've already talked about being proactive and how important that is. And one of the tools that can come in very handy for dealers getting ready for the vehicle shopping rule is the document compliance review, which we've already touched on a little bit. First off, I do want to touch on one fact. It is not a legal review, and we do not offer legal advice with these document compliance reviews. It's simply a tool that the dealership can use, we can provide, and it can help address existing areas of compliance risk in the core F&I documents. It's a very simple process that we go through. We have compliance consultants that will go to the dealerships on site, work with the F&I managers, and do collections of all of the customer-facing core F&I forms. From that point, they send them into our review team, which consists of attorneys with extensive experience in automotive consumer finance law. And they're going to analyze those forms for 5 key areas, which I'll touch on in a second. But the next step, they would send that data back to the compliance consultant, who would then set up a meeting with the dealer to review our findings, go over the key areas of risk, and talk about some potential solutions. The key areas of risk that we look at in these reviews, number one, it's going to be outdated documents. We see a lot of state forms that are outdated. And a lot of the state DMVs will continue to accept these forms. But from a best practice standpoint, it makes sense to update those as they need to be. The last thing you want are as a dealer are deals getting kicked back because you're using an old form. Form improvement would be another big one, where we have dealers using the same form that they've been using since 1997. We've actually seen revision dates from the 90s, believe it or not.
Wow, that's wild.
A lot of dealers that have transitioned from paper to e-forms, they just took whatever they were using on paper and had them programmed into e-forms, and they're still using the same stuff. So there's a lot of problems that can go on with that. So we will help identify the forms that come short. Open areas of risk. So we look at the deal jacket. Are there gaps? Do they have some glaring holes that we can easily plug? We identify those. Conflicting language we already talked about, and standardization inconsistency with groups. Every group that we work with would love to wave their magic wand and be using all of the same forms at all of their stores. The reality, Jen, is that does not happen.
Right.
And a lot of these groups that have grown real fast, they've bought, they've acquired a pocket of stores in one town, some stores in another town, and oftentimes
didn't unify the systems, didn't revisit the paperwork. Things are not so consistent amongst store to store.
Exactly.
I see. I know that.
And
it is on different products.
And from an accounting standpoint, from a management standpoint, from a compliance standpoint, it's a big problem. So those are all things we can help with. And then Matt mentioned the Reynolds Amplify Summit that we're really excited about. That is August 19th and 20th at the Lansdowne Resort in Leesburg, Virginia. It is open to all franchise dealers, again, regardless of DMS. It's a 2-day event that focuses on growth, discovery, and connection in the automotive industry. Matt and I are going to do a little bit deeper dive on the topic that we're discussing today, but I know there are multiple other sessions on multiple other topics that will be other
breakout sessions.
As well. Yeah. Details and registration can be found at rayray.com/amplify.
I'll put a little info in the show notes too, so people can take a look at that. Well, I want to thank you guys for joining me today and sharing your expertise, your insights. I think we all have the same goal, which is how can we protect dealers from all of those, what do they call those? A little slap on the wrists. But those are big fines that people are talking about out there. Right. And we've seen it happen with texting, and we've seen all sorts of things emerge. One thing that I just want to point out is that Reynolds and Reynolds continues to dominate when it comes to revising forms to stay present. And in this case, even thinking about what could happen with the vehicle shopping rule, should that go into effect. So already ahead of it. But one thing that you mentioned that I think we could close off in, and I think it is important for dealers, is to just reevaluate the processes. A lot of times we get into the grind, and so we don't always tighten everything up, but this is a reminder, if you're listening to this, that you go back and evaluate how your pricing is being presented, and what that looks like, and questions customers have, and what they might have, and how we respond to those, and just tightening up so that we stay in the good, because a lot of things can happen, but a lot of times, we just try to sell cars, and then we don't go back and reevaluate how we're presenting information to customers, and there could be some cleanup work there.
Absolutely.
Well, guys, thanks again. I'll put your contact info and everything in the show notes so people can take a look at the event coming up that you guys are hosting, and I appreciate your time.
Thank you so much, Jen.
Thank you, Jen. Really appreciate it.
If you like these episodes and my sales game techniques, you should snatch up our latest dealer education program I'm hosting. It's called Jen's Remote Classes, and it's a 1-hour, once-a-week class with me alongside other dealerships all pursuing the same end game to achieve top 10% status in your dealership. For more info, hit me up. All my contact info's in the show notes. I want to hear from you. And follow Dealer Talk with Jen Suzuki right now to get notified when episodes like this one drop. This is Jen on the podcast Dealer Talk with Jen Suzuki. See ya!